the hearing in the appeal, Patmalniece against the Secretary of State for Work and Pensions.
My Lords, my Lady, we have the note which should be in front of your Lordship and your Ladyship. Grateful to Mr Coppell for putting that together. Yes. That gives you the people in 21A, and I understand what your Ladyship is now saying. I simply misunderstood you yesterday, I apologise. It's 21A read with 22. Yes. But you see why I was saying what I was saying.
You were using a shorthand.
Yes, and you were using the correct words. And I said to that there, it's a summary. The European Court will doubtless find other people who've got rights to reside shortly, but they'll be all right because the right to reside will cover those as well. But a summary of the law as at August 2005, which is the relevant date for this claim. Some of the EU provisions have changed, some of the regulations have changed, but that's the position. And we've set out at 4 the 21A people, and we've set out the 10 categories there. And then at 6, we've set out the 2-1 read with 2-2, and we've set out 11. I gave you an example of 4 yesterday, and that should assist your Lordship and your Ladyship in terms of seeing the range, the 21 categories of people.
Which were the 4 you gave us yesterday? Can you identify them? And I think I can see 3 as one of them. Is that right? Primary care was 4.
Yes.
Did you
the
pick the
categories
first?
that we dealt with yesterday, 4 is the primary carer.
Yes.
2 was the self-employed person who retired or was permanently incapacitated and then stayed in the state. The pensioner who came from abroad with a big enough pension to avoid being reliant on Social Security is 6, have retired, sufficient resources, and the general sweep-up of people who've got sufficient resources and come to live in Britain because they like it is 6.5.
6.5?
It's 6, subparagraph 5.
Sorry, 5, yes.
Yes.
Yes. Yes.
So those are the 4 examples that I gave. I was trying to short-circuit things by giving your Lordship's examples,
yes.
But your Lordship sees why I have them and what my point is about that. Those are the 21 categories of people who are covered, and the rule only applies to people who don't fall into that group. And you'll see that all of those have the characteristics of economic or social integration, and that's why they get it. And that's why it's independent of nationality, because it's a characteristic of economic or social integration.
And the list, as you say, is not intended to be exhaustive.
No, A, I may have forgotten something. B, less likely Mr Coppell may have forgotten something. C, the European Court may invent something. May recognise it as existing in law, something we haven't yet recognised. My Lords, I was dealing with the second of my questions in this simple case. Is it direct or indirect? Is it objectively justifiable? Does the Irish position change matters? And I was dealing with the second question, objective justification. I had identified yesterday the primary source of the description of what the policy is, which was the statement of the Secretary of State, which I took your Lordship to. Can I just show you the 4 paragraphs in the Court of Appeal judgment that identify the policy?
Yes.
Because with the very greatest respect, there's quite a lot of analysis of paragraphs where the Court is responding to the appellant's case and wasn't dealing with our quite simple case, that this is objectively justified because it's based on economic and social integration as opposed to people who wish to come to live off benefits. So if I could just take you to the 4 paragraphs in the Court of Appeal judgment that set out the policy, and they say the policy is justified. The judgment is in the appendix. It begins at page 3. The relevant paragraphs are paragraph 10 on page 6. The purpose of the introduction of that requirement was made plain by the Secretary of State in the statement I showed you yesterday. The underlying purpose of the introduction of a right to reside test into a UK social security system was to protect that system from exploitation by those who do not wish to come to work but to live off benefits. The committee had taken the view that the existing habitual residence test was sufficient to prevent benefit tourism. The Secretary of State, however, concluded that the habitual residence test was ineffective in withholding entitlement to income-related benefits from those who had decided to live in the UK indefinitely without being economically active. It refers to paragraph 14, which I read yesterday, and then said it's intended to fill a gap in the measure to safeguard the public purse against exploitation by people with no right to reside here. Then paragraph 27, which is the paragraph referred to in paragraph 33 of the Statement of Facts and Issues. Paragraph 27, the justification advanced for the distinction is the same as that advanced in Abdurrahman and Kazmarek. The claimant is a non-economic migrant who cannot support herself. She has never worked in the United Kingdom, and the transitional arrangements for Accession 8 nationals, including Latvians, means that she could not derive a right to reside from work seeking. In those circumstances, it is both legitimate and proportionate to seek to protect the resources of the United Kingdom by refusing her a means-tested benefit.
Yeah,
that's what we said the justification was, and that's what 33 was meant to capture together with paragraph 10.
Yeah, I mean, that is a crucial sentence, the last sentence, isn't it?
Yes.
And we need to be quite sure how you seek to justify that.
Exactly, yes, that's the critical question.
And you're coming on to
case.
do that.
Yes, shortly. I've largely shadowed it because what I've said is it's based on economic and social integration, and that is acceptable. But I'll be showing you in just a moment the 3 reasons why that is correct.
Yes.
But I'll just finish off the Court of Appeal, if I may. And then if you look at paragraph 45, 46 and 47, paragraph 45 says the justification on which the United Kingdom relies must be assessed in the context of the purpose of 1408-71, and that purpose is to coordinate and harmonise social security schemes, not to create rights, but to coordinate and harmonise social security schemes so as to preserve the greatest possible freedom of movement for workers. And the regulation was designed, the objectives of it was to deal with the rights of workers to move and establish themselves. And then 46 and 47 come back to our justification. In order to achieve that objective, workers and their families and those seeking to work must not be inhibited from exercising their rights of movement within the member states by being exposed to disadvantage in relation to social security benefits. The requirement of economic integration, which the conditions in 21A of the regulations imposes in its reference to a worker or a qualified person, is consistent with that objective. Absent economic integration, the imposition of a requirement of social integration, which the right to reside condition in 2.2 imposes, does not impede the objective underlying 1408. All it's saying there is, if you've got economic integration, you're obviously meeting the requirements of 1408, and in the absence of the economic integration, the imposition of social integration requirements is acceptable. You've worked there, or you're the spouse of a dead worker, or all those other people that I showed you. And once it's acknowledged at paragraph 47 that the purpose of the regulation was to prevent obstacles to free movement of workers, their families and others seeking integration, there can be no reason why the country of residence should not be permitted to justify conditions of entitlement which reflect either economic integration or a sufficient degree of social integration. The requirement of a right of residence does not in any way affect Miss Patmalniece's right to her Latvian pension, which she is entitled to export to the United Kingdom by virtue of Regulation 10.1. It does not inhibit the objective of 1408-71. It imposes no disadvantage whatever on her in the exercise of freedom of economic migration within the community. It merely ensures that since Miss Patmalniece is not working, she must achieve the necessary degree of social integration before she becomes a burden on the United Kingdom's social assistance system, unless, of course, she acquires a right of residence.
Now, as I understand the structure of the judgment, Mr. Lewis, the Court of Appeal get there by classifying the benefit we're talking about as a hybrid.
Yes.
And you see this at paragraph 40 and 41, I think.
Correct.
Because he's got to get himself within the area of social assistance, doesn't he?
No, the way that...
Is that not what he's saying? I mean, he's getting away from the pure benefit, social security benefit, into the area where you can actually engage with the points which you've been reading out to us about integration and so on, which I thought was part of the social assistance problem. So hybridity, as I understood the judgment, was crucial to getting to the point you've read to us.
No, my lord.
Is
with
that
respect,
not right?
It was not. Hybridity was critical in the reasoning for this reason. We say Article 3 prohibits indirect discrimination, and then you have to look at whether it's justified. In looking at whether it's justified, you obviously look at the characteristics of the benefit. Something that's a contributory benefit is much harder to justify taking something away that people have paid for, as compared with something that is a social assistance benefit. So we say the label doesn't matter, whether it's a hybrid or whether it's social assistance, it doesn't matter. What Mr. Cox argued below was that unless it was in 4.4,
Yes.
a purely social assistance benefit,
Yes.
it could not be justified by reference to considerations dealing with protection of the system from exploitation.
Right, so, and the fact that it's listed in the appendix takes it out of any consideration of 4.4. Is that
Yes.
not right?
Exactly, and that's what Mr. Cox was saying, and I'll show you the paragraphs in just a moment. And he was saying you can't rely on these kinds of Abdurrahman justifications for things that aren't 4.4. You could, because here you're in the hybrid 2A, and he said, therefore, you can't look at those justifications. And you see that from paragraph 30 and 31 of the judgment. If I could take you to 30 and 31.
Yes.
Could we just look at 30? Because 30 is absolutely accurate, we say, in terms of what it describes. It's not just accurate for Abdurrahman and Kazmarek, which is accepted. It's correct for Trajani, and I'll be showing you that. But one needs to read it. It is important to appreciate, this is page 10, paragraph 30, it is important to appreciate that both this court and the Court of Justice have accepted, as part of the ratio of their decisions, the proposition that to preclude those who are not economically active and not self-sufficient from access to social assistance, by depriving them of a right of residence, pursues the legitimate aim of protecting the public finances. The first point there is Trajani is correct. What it says is you don't have a right to residence and under EU law, and therefore you can't say you've got a right to benefits, unless, of course, you have a national law right to reside. So that's why it's correct, because what Trajani did, and I'll come back to it later.
Just let me stop, don't go too fast. The first sentence is talking about social assistance.
Yes.
Isn't it? I mean, that's the point I'm raising with you.
Yes, I'm coming on to that. I've gone into a slight digression to deal with the first paragraph, the first sentence, and I'm saying that's correct, because all three courts, Court of Appeal twice, Court of Justice, did say you don't have a right to residence, and by denying them a right to residence, that meant they didn't have social assistance. Now, it's the next sentences in the paragraph that your Lordship is asking about.
Yes.
Of course, in Abdurrahman and Kazmarek, the effect of that conclusion, i.e. if you don't have a right to reside, you don't get access to benefits, was to exclude the alleged discrimination from the scope of the prohibition. But it does not necessarily follow that the proposition for which those cases are authority loses its force when considering the justification for discrimination within the scope of 1408. All the court is saying there is the same concerns, protection of the exchequer from those who are not coming to work but coming to live off benefits, applies when you're dealing with Article 3, just as it did with Article 12. It's the same considerations underlying them both. And then at paragraph 31, Mr. Cox distinguishes these cases because the benefit in the instant case does fall within the scope of the prohibition against discrimination on the grounds of nationality.
Now that's because of the listing in the annex. Sorry, listing in the annex does that?
Yes, hybridity, yes. It's in 2A and the annex, yes. And Mr. Cox said once you're into 2A, as he says, you can't then rely, he said, on the kind of distinctions about social assistance that you could if it was solely in 4.4. That's the way the argument was put in the Court of Appeal. We were saying, very straightforwardly, income-related benefits, for people who come here not to work but to live off benefits, we are entitled to refuse them. We're entitled to have rules based on economic and social integration. And we said it's as simple as that.
So you look at the nature of the benefit.
Yes, nature and function of the benefit and the circumstances of the individual.
But I had understood Mr. Cox is still saying, as a fallback or an alternative argument, he says if he's wrong on direct and indirect and so forth, he still, as I understood it, still has this fallback position that this is to be regarded as social security within this particular 2A, and therefore you can't have this justification.
Exactly, that is.
He is still saying the argument that is in fact met in paragraph 31.
As I understand it, yes.
Yes, I'm sorry. I thought you were suggesting that he'd abandoned.
Oh, no. Then that's my fault. I was trying to explain to my Lord how it arose in the Court of Appeal.
Yes.
And as I understand, as I understood what Mr. Cox was saying on Monday, he's saying the same thing.
Yeah.
We are saying this is very simple. Look at the nature of the benefit, look at the functions it performs, and look at the circumstances of the individual.
So that's why you say look at the policy statement by the Secretary of State.
Exactly, yes. Look at the nature of this benefit. It's incomes related. It's to help people who are needy, in the old-fashioned language. So that's the characteristics. It's income related. It's not something you've paid for. It's something you're given. Look at the functions. It's minimum subsistence. Look at the circumstances of the individual. People who are coming not to work, but coming to live off benefits. And we say benefits in those circumstances, or rules governing eligibility for benefits in those circumstances, can be justified. We don't care what label you put on it, frankly. We don't care whether you call it 2A or 4.4 and get very excited about the label. We say, look at the substance. Look at the nature of the benefit, its characteristics, what it is there for, and who is claiming it.
What was the purpose then of listing it in the annex and bringing it in?
The purpose was, initially, the regulation operated as if there were two things in the world, social security and social assistance. And if something was social security, you could get it in England, and then if you moved somewhere else, you could get it in the country that you went to. But that doesn't work for means-tested benefits because they are geared to the amount of money you need in the country concerned. So if you go from England, which is very expensive, to Latvia, which is very inexpensive, you don't need the means-tested element. But because the initial regulation had worked on a two-stage thing, it's social security or it's social assistance, once they said, oh, it's into social security, you couldn't take it away from them when they moved. So what they did with the amendment to the regulation was to create a hybrid category, and then, yes, it's 2A, it's state pension credit, it's income support and so on, but if you leave under 10A, you can't take it with you. That's it, essentially.
You can take your old age pension with you,
But not your means-tested benefit.
as indeed the appellant has done.
Exactly. Because you couldn't justify taking away something that you've contributed for. You can't say you worked for this all your life, you've had the audacity to quit Latvia, we're taking it away, and Regulation 10 says you can't. But that's different because we're not into that, and that's why we say you must look at the characteristic of the benefit and the circumstances in which it's paid. And we say you don't look at labels, you look at functions. And it doesn't matter if it's 2A or 4.4, you look at the nature, function and circumstances in which it's paid.
Yes.
That's the first argument. The second
So
argument
just again, forgive me, just looking back at the Court of Appeal, paragraph 40,
Yeah,
just to catch how they're putting it.
yeah.
I think they're just saying exactly what you're saying in the second sentence, just to get my bearings on
Yes, exactly. That's right, my lord.
this. Yes. And that's the distinction in 41. Yes.
And my lord, that's my first submission. It matters not a jot what you call them, it matters what they are. A rose, by any other name, my lord, will smell as sweet. Means-tested benefits, by any other name, will test as sour. You get them to reflect the extra cost of the country that you're in. If you come to this country, never having worked, to live off those benefits, we say it's legitimate to have rules saying, well, you can't do that, because you've got no economic integration, you've got no social integration, 21 categories of people get it, you are in the 22nd category and you don't get it. It's as simple as that. That's why it is a simple case.
And you find the foundation, this, as it were, the community law base for this in what is said in regulations, or in dicta of the court?
Three things support what I say. Firstly, it's consistent with the purpose of 1408.
Say what?
Firstly, my submission that rules refusing benefits to this category of people who come not to work but to live off benefits is consistent with Regulation 1408/71.
No, you have to say why. It's an
Can I give
assertion.
you the three and then I'll say why in turn? Can I give you the three headlines and then I'll deal with each in turn? I'll make the assertion and then I will justify the assertion. But let me make three assertions first and then I'll elaborate. It's consistent, the purpose is consistent with Regulation 1408/71. Secondly, it is a purpose that has been held by 5 members of the House of Lords, 3 of whom sit in this court, as a legitimate purpose in Zaleska. And thirdly, it's consistent with the case law of the European Court in Troiani.
I thought you were going to, in your case anyway, you referred to regulations, don't you? Is it the residence regulation?
Yes, it's consistent with the regulations are consistent with the aims of 1408/71 and reflects and is consistent with all the regulations governing the circumstances in which you have a right to reside under EU law.
Yeah.
The directives and the regulations governing when you get a right under EU law. It's consistent with the entire mass of EU social security / residence regulations. It's upheld by Zaleska and is consistent with Troiani. Those are my three assertions. I haven't got beyond assertion yet.
Yeah.
If I can deal with the first of those points, it's consistent with the aims of community legislation. Firstly, so far as the residence directives are concerned, everyone who has been given a right to reside by EU law in the United Kingdom is brought within the scope of Regulation 2.1. They're either within 2.1a, and it is easier for them than it is for UK nationals, because they're automatically deemed to be habitually resident, or they're brought within 2.1, read with Regulation 2.2, and they have to show they're habitually resident, in fact, just like a British person, and there is no discrimination. So, where EU law has given all these rights of residence, they are properly reflected in the British regulation. More favourable treatment for some EU nationals than UK nationals, or the same treatment. It's consistent with the aims of Regulation 1408/71 for this reason. 1408/71 is concerned to facilitate the free movement of workers and the self-employed. It's concerned to make sure they don't suffer disadvantages by going from one state to another to work, and indeed their family members are not deterred from going with them as well.
Now we find that in the recitals, do we?
Yes, and you find it in two cases which I'll give you in just a moment. It's sorry, I lost the oh, here. Yes, it's tab. Funny. I lost. Oh, here we are. Tab 16, I think. Is that right?
Yes.
Yes, it is. Yes, at 16.
If your Lordship has the recitals, it first of all is coordination of national security systems. It's not creating rights, it's coordination. If you look at the first recital, whereas the provisions for coordination of national security legislation fall within the framework of freedom of movement for workers and could contribute towards the improvement of the standard of living. Free movement of persons, one of the cornerstones of the community, confined not to employed persons but extends to self-employed. 3, there are considerable differences existing between the national legislation. 4, it's necessary to respect the special characteristics of national social security legislation and to draw up only a system of coordination. 5, necessary within that framework to guarantee equal treatment under various national legislations to workers living in the member states and their dependents and their survivors. 6, whereas the provisions for coordination must guarantee that workers moving within the community and their dependents and their survivors retain the advantages and the rights acquired in the course of being acquired.
Yeah.
And next, where these objectives are to be obtained by aggregation adding together the rights that you've acquired elsewhere.
And retaining them.
So what you see there is, what they're saying is, this is all aimed at maximising equality of treatment for, guaranteeing equality of treatment for workers and ensuring they're not put at...
Would you just read the next recital? Whereas those
yes,
objectives...
sorry, I'm being asked to do three things by three different people.
So
If I could just have a moment. Whereas the instances in which a person should be subject simultaneously to the legislation should be as limited in number. That's to make sure you don't have two sets of legislation, you have one applying. Whereas with a view to guaranteeing the equality of treatment of all workers occupied on the territory of a member state, it is appropriate to determine the legislation applicable as a general rule, that of the member state in which the person concerned pursues employment.
What are you reading from? I beg your
The
pardon.
bottom of the page, what my friend asked me to read out.
No, I'm so
it's
sorry.
an extra.
I was asking to read the previous.
Yes, you see,
Oh, the
Whereas
previous.
these objectives must be
it's quite
attained.
important because of the last three lines, I think,
Yep.
is what Mr. Cox is drawing our attention to. Because
Yes, well, your Lordship has it.
you-
I'm sorry, my lord, because I apologise. I've been asked to do three things by three different people,
Well,
and I'm not
take
sure
your
what I've been
time,
asked
take
to do.
your time.
Could I just ask my friend Mr. Cox to tell me what it is that he wants me to read?
I'm so sorry. It's the paragraph, the recital that begins, whereas these objectives must be attained.
It's the
Right.
fourth.
Whereas these objectives must be attained, in particular, by aggregation of all the periods taken into account under the various natural legislation. Can I just pause there? I'm coming back to the rest. Don't worry. That just means if you've got 3 years in Latvia, 3 years in Lithuania, and 6 years in France, you add them all up. You're not disadvantaged, and you don't lose 3 years by moving. For the purpose of acquiring and retaining the right to benefits and of calculating the amount of benefits, and by the provisions of benefits for the various categories of persons covered by the regulation, regardless of their place of residence within the community. And that's absolutely right. If you've got 3 years in Latvia, 3 years in Lithuania, 3 years in France, it doesn't matter where you live, you keep all those years. In this case, there's no aggregation issue. She only has pension rights from Latvia, and she keeps those in England. Nobody's taking away her Latvian pension rights. If she had 3 years in Latvia and 3 years in Lithuania, and you'd have to give her 6 years, and then when the 6 years came to England, she'd get the 6 years. But that is aimed, as I'll show you in just a moment from the EU case law, that is aimed at making sure that people don't suffer a disadvantage by moving between states, so they never get 5 years in one state, but they might have 5 years in 2 states added together. That is all that is saying. It is preserving rights acquired under different national legislation and making sure that if you move, you don't lose those rights. But that is not the situation that we are dealing with here. So those regulations, and I'll show you 2 paragraphs of 2 cases in the European Court just to summarise the recitals and the purpose, and then I'll show you the parts in the Court of Appeal judgment where this purpose is summarised.
Yes.
May I just show
Are you leaving the recitals, Mr. Lewis?
Yes.
Because it struck me that you just at a quick glance that the second full paragraph on the following page.
Yes, it's helpful too.
It's helpful.
I was going to come back to it later, but shall I draw it to your attention now?
Just while we're looking at it, yes.
Whereas certain benefits foreseen under national laws may fall simultaneously within social security and social assistance, because of the personal scope of their application, their objectives and the manner of application, it is necessary to lay down a system of coordination which takes into account the special characteristics of the benefits concerned. That should be included in the regulation in order to protect the interests of migrant workers in accordance with the provisions of the treaty. Just pausing there, that's the other point in response to the discussion that your Lordship and I had. The recitals make it clear that some benefits fall at the same time within social security and social assistance. They have characteristics of both.
So this is authority for the hybrid concept.
Exactly, yes. And that's saying they don't cease to be social assistance. They don't merely have characteristics of social assistance. They are social assistance. They may also be social security, depending on the circumstances that you're dealing with. But that's why you look at, they call it, the personal scope, their objectives and the manner of application. And I called it the characteristics of the benefit, the function of the benefit, and the circumstances in which it's paid. But that reinforces the submissions I made a short while ago on that point.
Would you just read the next paragraph?
Whereas such benefits should be granted in respect of persons falling within the scope of this regulation solely in accordance with the legislation of the country of residence of the person concerned, or of the members of his or her family, with such aggregation of periods of residence completed in any other member state as is necessary, and without discrimination on the grounds of nationality. And that's absolutely right, solely in accordance with the legislation of the country of residence, the United Kingdom, and that is the residence requirements in 2.1. All that says is you look at the legislation in question to see whether they get them. And we are looking at the legislation in question, and that is Regulation 2.1. So if we can just stand back from what we've just looked at globally. The purpose is to facilitate the free movement of workers. A number of factors that you've got to bear in mind. People and their family members shouldn't lose benefits by going from one state to another. So if you've got 10 years clocked up in France, you shouldn't lose that because you moved to Belgium. You shouldn't lose out because of the fact you've worked in more than one country, aggregation. If you've got 10 years in Belgium, 10 years in France, you shouldn't lose any of those rights when you go to Germany. Because you'll be deterred from going to Germany if you're going to lose your rights. So that's what that is aimed at. And that's what the function of this is to facilitate free movement of workers, very broadly understood, because it also covers family members, because you might be deterred from going to Germany if your wife lost her benefits. And that is what it is concerned with. It is coordinating benefits so people who move aren't put at a disadvantage. But what we are dealing with is something quite different in these regulations. It is people who come to the United Kingdom not to be economically active, or who are not economically active, who are not socially integrated, but want to claim additional means-tested benefits. And that's what this regulation is, the British regulation is about. And there's nothing in the British regulation which runs counter to the EU social security legislation. We don't stop people bringing their Latvian pension with them. We don't stop aggregation of different periods in different member states. We don't say, yes, you can come, but don't you dare bring your husband, we're not having him as well. None of that happens. All that happens is, if you don't come to work and aren't integrated, but you come instead to live indefinitely off benefits, that you can't do that. And that is consistent with and does not run counter to the regulation. Can I just show your lordship the
Why you can come to live off the benefits listed under Article 4.1, can you?
Yes.
Why?
The strict answer to this is yes, you can come. We may be able to have some restrictions if they were justifiable, but it is hard to justify access to benefits that you've contributed to. If you come to England,
That you have contributed to or not contributed to.
that you haven't, that you have contributed to. If you come to England and you work, and you've got 15 years and you get 15 years pension, then we can't take that away from you. It would be unjustified.
No, of course. But I talk about people who haven't worked in England. They've come, like this lady.
Yeah.
Why does she get 1C old age benefits?
The short answer is she wouldn't get old age benefits if she hadn't made contributions, because she's got to make the contributions to get it. You don't get the state pension. You've got to have, is it 44 years or whatever many years they say? You only get a pension under the legislation requirements. And for an old age pension, you don't just come in and say, excuse me, I'm 60 and I'm here. Where's my pension book? You have to have contributions.
I see.
What about paragraph 4.2? What's it saying there?
Oh, that just says that you can't assume that a non-contributory pension benefit is outside there. And that's why child benefit, presumably, is covered. But you've got to look at the risks. There is the risk, a nice way of putting it, of old age benefits, or the risk of being old, I suppose, but sickness and maternity. But what you do is you get it under the legislation. So we have given child benefit to everyone who's got a child, unless they're very wealthy.
Or they don't have a right to reside. Or they don't have a right to reside.
Or they don't have a right to reside, yes. And unemployment benefits, to give another example, the system is, in this case called Vatsuras, because you want free movement of benefits, you want to help people into work, so they do get access. People who are entitled as workers or work seekers to go to another member state do get a job seekers allowance because they're entitled to go and look for work. Not Accession 8 nationals because there's a derogation. So that's why unemployment benefits, because it's connected with putting people into work. Old age pensions, because if you've made your contributions, you should get your pension. But what you'll get if you've done 2 years' work is 2/44 of the whole thing, not the lot.
And we contrast that with 2A then, which
Yes,
are described as
2A,
special non-contributory.
Special non-contributory cash benefits, which are provided under legislation which, because of its personal scope, objectives, and or conditions for entitlement, has characteristics both of the social security legislation referred to in paragraph 1 and of social assistance, the point we've been debating. Special non-contributory cash benefits, which means those A, which are intended to provide a supplementary substitute or ancillary cover against the risks covered by paragraph 1, and which guarantee the persons concerned a minimum subsistence income having regard to the economic and social situation in the member state concerned. That's the means tested element, the minimum subsistence level. And then 2 is something else. And where the financing exclusively derives from compulsory taxation, intended to cover general public expenditure, so it doesn't catch contributory benefits, and which are listed in Annex 2A. Now, that means that if Miss Patmalniece had come here with a 20 years Latvian pension, she'd worked for 24 years to get a British pension, you'd add those together, she'd be in this country, she'd be integrated, she'd have been economically active, and she would get the minimum guarantee credit for the state pension. If she's this widower, she couldn't be a widower, what's that? Widow of a worker, she will also get the benefits. And there's a whole series of 21 categories of cases. If she'd actually, if her asylum claim had been successful and she'd been granted leave as a purely domestic matter, she would have got it. The reason why she doesn't get it is because this is intended to be a minimum income guarantee. It's paid out of taxation, not contribution. But it is not paid to those who do not come to work or are integrated, but come to live off benefits. And it really is as simple as that. It is a question of whether that policy, to say that all those who are economically or socially integrated can have these means-tested benefits, but it's permissible to say, if you come not to work or to be integrated, but to live off benefits, you can't have them. The simple question for this court, after 2 days, is that objectively justifiable or not? Or do we have to give benefits to all and sundry with no connection with this country who simply happen to be here, like Mrs. Patmalniece?
I mean, if you're right, then, I mean, you accept that it means that this category of persons doesn't get even the minimum subsistence.
No, she doesn't.
Does it mean that?
Yes.
It means that, absolutely.
No,
I
she
mean,
doesn't
in
get it.
effect, I mean, one doesn't want to be emotive, but I mean, you say you can, so to speak, starve them back to their own country.
What we would say, my lord, is that Mrs. Patmalniece has a number of choices. She has worked and has a Latvian pension, which reflects her contributions in Latvia and which presumably is related to the cost of living in Latvia. And for all I know, Latvia has benefits. If she wishes to return to Latvia, the assumption is that that is how she will live. If she chooses to live in the United Kingdom, then she must work or establish one of the other categories of social integration. And that is her choice. But it is not the case that 360 million EU nationals are entitled to come here and say, I know I've never worked here. I know I've got no connection here, but I'm here now. I'd like my minimum subsistence guarantee. And that is not the extent to which EU law goes at present.
I mean, well, I think I have asked everybody so far, what is her immigration status here? I'm not sure I really understand it to this moment.
She is present in the United Kingdom, full stop. She is not committing a criminal offence. She is liable to be removed, but she has not been granted any right to, I'm talking about 2005, she was not granted any right to remain in domestic law. She wasn't given indefinite leave because she was a refugee. She wasn't given temporary leave for some other purposes. She had no rights under domestic law. She has never had any EU law rights. And she is simply somebody who is present and whose presence does not involve any illegality. But she is not somebody who is lawfully resident in the sense that she either has a right to reside under EU law, which stops her being removed, nor does she have a right to reside under domestic law. And I'll be showing you the cases at Duraman in just a minute. She is present, but she does not have an EU law right to reside and has never had one at the material time. And she does not have a domestic law right to reside because she asked for one and it was refused. Would your Lordship like to see Abdurrahman and present?
I don't know.
I'll show it to you in due course, I think, but at the moment that's the answer to your Lordship's question. When she came in 2000, she certainly was not exercising any treaty rights because Latvia was not a member of the EU. She applied for asylum, and we couldn't remove her because the convention said you can't remove people who've applied for asylum, and that was refused, I think, in about early 2004. So at that stage, she had no right to be in the United Kingdom. She had applied for asylum and it had been refused. She could have been deported at that stage. After 2004, her position did not change because she was an Accession 8 national. She says she looked for work, and if she'd been French, that would have been enough, because you have a right to come to look for work. But the Accession 8 states only have rights, because of the transitional arrangements, if they are actually working for a registered employer. So she never exercised any treaty rights at all.
Does the case of Zalewska tell us something about Accession 8?
Oh, it certainly will, and I'll be going there in just a moment. I'm en route there, that's my next port of call, and I've dealt with the legislation.
What a shame.
Well,
it's a case where all five were agreed that the requirements in the policy were lawful. Two dissented on an issue of proportionality, which is not in question here. And the Supreme Court is bound by what it said previously, but fortunately, 3 of the members of the House of Lords Committee are on this court, and I doubt that they will have changed their mind.
Well,
but we will look at it in just a moment.
Said, I think. Let's just see. Anyway,
I haven't showed you the 2 cases, the 2 paragraphs in the 2 cases that say what the purpose of these regulations is. Would your Lordship find that helpful?
Yes,
then could I ask you to go to tab 6, volume 6, beg your pardon, volume 6, tab 68, and a case called Khalil. And could I ask you just to go to 65 on page 1281. Does your Lordship see the heading Findings of the Court?
Not got there yet. 65. Findings of the Court, yes.
As regards stateless and refugees, that's what it says. And then 66, the principal objective of Article 51 of the EC Treaty, which is the one under which it was made, is coordination of the social security systems of the member states and the payment of benefits under those coordinated systems. On the other hand, it is clear from the Court's case law that the essential objective of Regulation 14/871 is to ensure that social security schemes governing workers in each member state moving within the community are applied in accordance with uniform community criteria. To this end, it lays down a whole set of rules founded in particular upon the prohibition of discrimination on grounds of nationality or residence, and upon the maintenance by a worker of his rights acquired by virtue of one or more social security schemes which are or have been applicable to him. So it's non-discrimination, and we say this isn't discriminatory, and the maintenance of rights acquired by virtue of one or more social security systems.
Would you just read the next paragraph?
68. Admittedly, the Court has held that the fact that 4.1 of Regulation 3 is substantively identical to 2.1 even refers to persons who come or have come under the legislation of a single member state, shows that far from referring solely to migrant workers within the strict meaning of the term, Regulation 3 is applicable to any wage earner or assimilated worker who finds himself in one of the situations involving international elements as provided for in the said regulation. But 67 is the one about purpose. And then could I ask you to go to one other EU case for one more paragraph, and that's in volume 7, and it's tab 78, Spreet. And if I could ask your Lordship to go to page 898.
Just give us a moment. Yes.
18 at page 898. In that respect, it should be noted first that the provisions of Regulation 1408, and in particular those of Annex 6 that were adopted to implement Article 51, and must be interpreted in the light of the objective of Article 51, which is to contribute to the establishment of the greatest possible freedom of movement for migrant workers, which is one of the foundations of the community. Article 51 requires the Council to adopt such measures in the field of social security as are necessary to provide freedom of movement for workers by securing payment of benefits for persons resident in the territories of the Member States. The aim of Articles 48 to 51 would not be attained if, as a consequence of the exercise of their right of freedom of movement, workers were to lose the advantages in the field of social security guaranteed to them by the laws of a single Member State. Consequently, the purpose of Article 10 of Regulation blah 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 concerning the waiving of residence clauses is to guarantee the person concerned his right to social security benefits even after taking up residence in a different Member State, and to promote the free movement of workers by insulating those concerned from the harmful consequences which might result when they transfer their residence from one Member State to another. People who move from Latvia to England can take their Latvian pension with them. They can aggregate the pensions, look at Khalil. They can't be discriminated against, and that is the purpose of it. But it is not to provide social assistance or benefits having the characteristic of social assistance to those who come to a state not to work and having no social integration, but to live off benefits. That provision does not run counter to Regulation 1408/71 and reflects the residence regulations and directives of the EU. That's the first point.
Yes.
The second point is Zaleska. And Zaleska is in bundle 3. At tab 43. A court comprising Lord Hope of Craighead, Baroness Hale of Richmond, Lord Carswell, Lord Brown of Eton under Hayward, and Lord Newburgh. And it concerned, I call them A8 nationals. I trust everybody knows what I mean by an A8 national. It's when there was the wave of new accessions in 2004, the Central European countries, the Czech Republic, Slovakia, Slovenia and so on, and the East European ones, Poland, and any other country that's in Eastern Europe that joined. They were the A8 nationals. Workers normally include, for the 15 original states, included people who were coming to work. So the French person who got on the Eurostar and came to London to look for work would be a worker and would get benefits. But for the A8 nationals, they were concerned about the potential impact of the A8 countries moving. So derogations were permitted to member states, and you didn't have to give the rights of workers to the A8 nationals. And what the United Kingdom did was not to give rights to A8 nationals who wanted to look for work. Under the workers' registration scheme, as I'm sure my Lord will remember, you had to be registered working for an authorised employer. Or if you had worked for an authorised employer for a continuous period of 12 months, then you were a worker. But you weren't a worker if you were looking for work, and you weren't a worker if you didn't register, as happened in Mr. Leska's case. She was actually here for 12 months, but she changed her employment and she didn't register the second time, so she wasn't somebody who was a worker under the transition arrangements. Your Lordships will recollect the facts of that. If I could take your Lordships to the judgment.
Just looking at the holding, if you wouldn't mind, just to see where we are. You say we needn't worry about the dissents. Is that because we're looking at what is
Because they didn't
effectively...
dissent on this.
You're looking at holding 1, are we? What is covered by holding 1, are we? Page 2603.
Yes. It's 2, really.
Oh.
That the United Kingdom, in regulating access to the labour market during the transitional period by means of the Workers' Registration Scheme, had sought to monitor the impact of accession workers on particular sectors of the labour market, and it was not disproportionate for such persons to be required to apply for a registration certificate for the first employment which they obtained in the United Kingdom, or to have to re-register if they changed their employment within a stipulated period. That the use of such requirements as a means of determining accession workers' entitlements to welfare benefits, so as to achieve the aim of safeguarding the benefit system from exploitation, was also, notwithstanding the consequences flowing from any failure to comply with the requirements, a proportionate measure to have adopted, and that accordingly the regulations were compatible with community law and the claimant had not been entitled to income support. And just breaking that down, the rules meant that she wasn't a worker, she couldn't get access to income support. That was a legitimate purpose. All 5 of their Lordships and her Ladyship agreed that it was legitimate. They all agreed that it was proportionate in terms of requiring the first registration, and where my Lady Hale and Lord Newburgh disagreed was saying, and if you don't re-register, you lose the status. But the purpose, which is the key thing here, was held by the House of Lords to be a legitimate purpose, preventing the exploitation of welfare benefits, and having rules which had the consequence that somebody didn't have the benefit was a legitimate purpose, as per all 5, was proportionate, as per 3 of you, for re-registration, but not proportionate as per 2 of your Lordships. And I'll take you through the judgment in some detail because it's quite important. It begins at paragraph 1. Sorry, that's a silly statement. Turning first to paragraph 1. On page 2605, the lead speech of my Lord Hope, and your Lordship describes the arrangements in 1 and 2. And question 3, the question in this case is whether the appellant, who is Polish and has worked in the United Kingdom without interruption for 12 months, qualifies for income support under the relevant social security legislation as a person who is habitually resident in this country. Now, she didn't qualify because although she'd worked, she hadn't done so for 12 months without interruption. Miss Patmalniece, of course, doesn't qualify because she has never worked in the United Kingdom and has no other basis for claiming social integration and is in a worse position than Miss Zaleska in that respect. Then your Lordship sets out the community law background. At paragraph 9, your Lordship described the national law governing the workers' registration scheme. Then at 15, we get to the income support. That's on page 2609, 15. In order to qualify for income support, a person must be habitually resident in the United Kingdom, the Channel Islands, the Isle of Man, or the Republic of Ireland. Unless he is habitually resident in one of these places, he will be treated as a person from abroad. That was income support, or state pension credit, and the test is in Great Britain, but it's essentially the same. The applicable amount for the purpose of income support in the case of a person from abroad is nil. And then you turn, my Lord, to the changes that we are dealing with here. Following the changes made to the 2000 regulations by the 2004 regulations, the income support regulations were amended. Prior to the amendment, the expression persons from abroad was defined simply as a claimant not habitually resident in the United Kingdom, Regulation 21.3. A person who was exercising a right of residence in the United Kingdom under community law was entitled to benefit. The effect of the 2004 amendments is that an A8 state national requiring registration under those regulations is to be treated as habitually resident in the United Kingdom, but only if he has a right to reside here. This is the effect of Regulation 21(3)(e), as inserted by Regulation 3 of the Amendment Regulations, which provides that for the purposes of the definition of a person from abroad, no person should be treated as habitually resident in the United Kingdom, Channel Islands, Isle of Man, or the Republic of Ireland if he does not have a right to reside there. That's 2.2 in our regulations on state pension credit, shared with income support. An accession state worker requiring registration has a right to reside in the United Kingdom only during the period while he is working for an authorised employer, and he does not cease to be an accession state worker requiring registration until he has worked for an authorised employer without interruption for a period of 12 months. So it is the same regulation. You can't be habitually resident unless you have a right to reside.
Was that amendment introduced exactly the same time as our amendment?
It's the same regulations.
Oh, it's the same, okay.
It's tab... It's tab 10.
Yeah.
It put the test into all of them, my lord, if you look.
Well, it's not tab 10, it's tab 9, isn't it?
Oh, tab 8, I beg your pardon.
Tab 8. Tab 10 is
tab 8.
treaty. Yes. Sorry, yes.
And you'll see, if you turn to page 2, you'll see the income support regulations that was put in there, and on the right-hand side, page 5, it was put into state pension credit.
Yes, I follow.
But it's the same test.
Yeah.
And in relation to Miss Leska, she wasn't somebody with the right to reside because she had worked for 12 months, but she wasn't registered. Miss Patmalniece chair, of course, never even worked, leave alone registered. And then you have the fact set out at 17, and that is basically what I've said. She was registered for the first employment, she switched and she was covered for the second employment, but then she worked for, I think it was mushroom picking, and she didn't re-register. So because she hadn't re-registered, she lost her right to reside. She'd worked, she just hadn't completed the requirements of registration. And because she hadn't completed the requirements of registration, she had no right to reside. And because she had no right to reside, she had no right to income support under the regulations, because you were denied income support if you didn't have a right to reside. And then if we go to paragraph 22, we see there set out that the central issue is whether the registration requirements in relation to Regulation 7 of the Workers' Registration Scheme regulations, on which the appellant's right to reside in the United Kingdom under the Worker Registration Scheme are compatible with community law. And there was a first argument, which was that she was still entitled to rely on Article 39 and Article 7(2), and that's not relevant in this case, because she's never even worked in this case. And if that was right, then registration requirements were irrelevant. And her second argument is that the right to reside test, which is linked to the requirement to register the initial employment and to re-register all subsequent changes during the first 12 months, is unnecessary and disproportionate.
And Mr. Drabble supported that argument.
Yes, one would expect nothing less. And Mr. Lewis, you would expect nothing less, said no. He said what he said in paragraph 24, by all accounts. Yep. Yes, my alternative submission at 24, letter D, my alternative submission, which succeeded, because I lost on the first argument, his alternative submission was that the regulations performed a legitimate aim, protecting the revenue, as we've looked at all along, and were proportionate. And everyone in the House of Lords was with me on legitimate aim, 3 on proportionality, 2 were not. And then there's the discussion, and then if I could take your lordships to paragraph 31, obviously reading anything along the way that my friend wants.
You pick up paragraph 29, just below B, where it deals with Trujani.
My friend asks me to read paragraph 29. Would your lordship like to read paragraph 29 to yourself, or Would you like me to read it?
Well, I'm not quite sure what particular bits we're being
It's a
asked
simple,
to...
it's between C and D. There's a reference to Dajani and an explanation as to why it's irrelevant in this particular
Oh,
case.
yes, thank you very much.
But if your lordships would read to the end, because it shows
Yes,
why they
well,
couldn't
so we
rely on
read
discrimination.
from C onwards, would that be fair enough? Yes.
Okay, so, my lords, that's in the context of the first question, which is, did she still get it right under 7.2? And the answer was, we were allowed to derogate. I tried to persuade your lordships that derogation was entirely a matter for the member states, and you said, no, it's not. Community law still applies, and the normal rules, legitimate aim and proportionality apply. And I turn now to the question of justification, whether or not the measures that were an issue which led to her losing income support because she had no right to reside, were acceptable. And it begins at paragraph 31. This brings me to the issue about proportionality, which is the most troublesome aspect of this case. The principle of proportionality requires that the means employed to achieve an aim recognised by community law as legitimate correspond to the importance of that aim and are necessary for its achievement. There is no doubt that it was legitimate for the United Kingdom to exercise the right of derogation that the Treaty of Accession provides and to introduce regulations that gave effect to it. The question is whether a national measure which says that only those A8 state nationals who work for an authorised employer for an uninterrupted period of 12 months are entitled to the status of worker, having regard to the consequences of according to that status, is disproportionate. The consequence of the appellant's failure to re-register after she left the mushroom people was, as Mr. Jobble put it, a complete denial of community law rights. She lost the right to reside in the United Kingdom, and as a consequence of losing that right, access to social security benefits. Admittedly, she would qualify for those benefits if she were to work for an authorised employer for a further uninterrupted period of 12 months. But loss of access to the benefits for the time being is, it is said, too severe a penalty for someone who can prove that she has already worked without interruption for the whole 12-month period. 32 sets out, and I won't read it unless my friends want to, general case law governing the approach to proportionality. 33, Mr. Lewis submitted the differential treatment between nationals of the A8 states and other EU nationals that resulted from the worker registration scheme pursued a legitimate aim, and the purpose was to enable the United Kingdom to monitor and review the arrangements for access by A8 state nationals to its labour market to determine whether further steps needed to be taken to prevent its disruption during the accession period, and I refer to a case there. And then further down, just above letter C, as for proportionality, we submitted that the worker registration scheme was objectively justified. The United Kingdom adopted less severe restrictions than most of the other member states. And then 34 materials were shown to your lordships which provided some support for my description of the aims of the WRS. When the worker registration scheme was first introduced, its purpose was said to be to allow A8 state nationals access in a way that would enable the government to monitor the numbers, not expected to be a barrier to those who wanted to work. On the contrary, thought it would encourage those who were working illegally to regularise their status. 3 strands of thought can be seen to be at work. There's a concern about numbers, which is why there was a request for a derogation. There was a concern to identify which sectors of the labour market were being affected by the influx, so remedial measures might have to be taken to control it. And there's a concern about the number of A8 state nationals who are already working here illegally. The registration system was an obvious way of combating this abuse. All those are workers' registration specific. And then my Lord says this, 35, similar concerns about the impact of enlargement on the benefit system led to the amendments to the Social Security regulations that prevents the appellant from obtaining income support. the habitual residence amendment regulations, the ones we are dealing with, introduced into the income-related benefit rules for Great Britain the same amendment for the habitual residence test as that which was introduced for Northern Ireland by their regulations. They were referred, when in draft, to the Social Security Advisory Committee. The committee's report was presented to Parliament in April 2004. That's our statement, isn't it? Which is our statement, the one I took you to yesterday afternoon. Your Lordship remembers the one I took you to at page 53 onwards. So the committee, they were referred to, when in draft, the committee's report was presented to Parliament. In his introduction to the report, the Secretary of State said that the underlying purpose of the regulations was to safeguard the United Kingdom's social security system from exploitation by people who wish to come to the United Kingdom not to work, but to live off benefits. They were intended to support the government's policy of opening the United Kingdom's labour market immediately to workers from the A8 states. But it was recognised that any resulting influx of people from abroad might lead to additional and inappropriate demands on the United Kingdom's social security system. The appellant does not suggest, I think rightly, that these aims were not legitimate. Just pausing there, your Lordship has just identified correctly in my submission the aims, people who come not to work but to live off benefits, and concern about the consequences of that. And you say, I think rightly, that the aims were legitimate. Then your Lordship in the next sentence goes on to deal with proportionality. Now there's no proportionality argument put against me here. It is simply said that they're not a legitimate aim. It's not said they work more harshly, for example, on Miss Patmalniece, who has never worked, than they did, for example, on Miss Zaleska, who had worked for 12 months but hadn't registered. And turning to proportionality, your Lordship said, were the provisions of the 2004 regulations proportionate to those aims? And the debatable ground on this issue is quite narrow. I do not think that it can reasonably be suggested that it is disproportionate for A8 state nationals to be required to apply for a registration certificate for the first employment that they obtain. So the purpose is legitimate, and certainly first registration saying you'll only get the benefits if you work, if you register and work for an authorised employer, that's proportionate. And your Lordship says, why? And then your Lordship goes to 37, and as I say, all five of your Lordships and your Ladyship were agreed on paragraph 36, as I understand it, that the aims were legitimate, first registration was proportionate. 37, the debatable ground is whether the requirement that Article 8 state nationals must re-register if they change their employment within the 12-month period is proportionate. Mr. Draber did not criticise other aspects of the scheme as being either unsuitable or necessary. He confined the intervener's submission to the re-registration requirement, which he pointed out had not been addressed by the Court of Appeal in Northern Ireland or in England and Wales. He said that disbarring the appellant and others in her position from social security benefits because of a failure to comply with the formality of re-registration, despite the fact that she had worked here for an uninterrupted period of 12 months, impaired the very substance of the qualified rights that the Treaty of Accession conferred on A8 state nationals. It was a disproportionate penalty. The only point of the worker registration scheme was to count them on their first arrival. The consequences of the failure to re-register to the individual would seem, he said, to be wholly out of proportion to that aim. He was supported by the appellant at paragraph 38 and at 39. And at 40, your Lordship said, then there is the important question of access to social security benefits. Because, of course, the consequence of not re-registering is she lost access. She had no right to reside and lost access. And the question is not having a right to reside, because of these circumstances, disproportionate? And you said the Secretary of State for Work and Pensions said in paragraph 4, which I read to you yesterday of his introduction to the report on the 2004 Social Security Regulations, that their underlying purpose was to safeguard the United Kingdom's social security system from exploitation by people who wish to come to the United Kingdom not to work, but to live off benefits. The terms on which Article 8 state nationals are to have access to the labour market are critical to achieving that purpose. Access to that market confers on them the status of workers. They become entitled to the same social advantages as nationals. The third paragraph of paragraph 2 of the annex provides that A8 state nationals admitted to the labour market of an existing member state following accession for an uninterrupted period of 12 months or longer are to enjoy access to the labour market. That is a right given to them by community law with all the other rights that go with it at the end of that paragraph. But it is given only to those who are, as the subparagraph puts it, admitted to the labour market during the period. And the proportionality of the formalities of registration and re-registration and of the consequences, loss of social assistance, the consequences of a failure to comply with these requirements must be judged in that context. Your Lordship then looks at Mr. Commissioner Rowland's justification, and I can take your Lordship through it, but it's set out at 41 and 42. We then have Mr. Drabble's submissions that the reasoning was flawed because he misconstrued the width of the derogation, and your Lordship agreed in part but said perhaps we're being a little harsh. It was a very compressed sentence, and so on. And then at 44, in any event, this point does not affect Commissioner Rowland's assessment of the issue of proportionality, which I would respectfully endorse. I think he was right to regard to the system which imposed some degree of pressure on nationals to register and the desirability of up-to-date statistics. The right that the accession treaty gives to regulate access to the labour market during the accession period carries with it the right to ensure that the terms on which access is given are adhered to. Regulation of the right of access and monitoring its exercise are appropriate and necessary consequences. Furthermore, it does not seem to me that there is any difference in principle between the consequences of late registration, which have not been criticised as disproportionate, and those that flow from a failure to register. They are the result in both cases of the same basic failure. The terms on which access is given have not been adhered to, so the rights that flow from it are not available. This may come with a cost, depending on the person's circumstances, but for the reasons the Commissioner gave and the other reasons that I've mentioned in the previous paragraphs, I do not think that the consequences in either case, when examined in their whole context, are unreasonable or disproportionate. So that is a clear acceptance, firstly, of the legitimacy of the aims in the statement that I showed your Lordship yesterday, a clear acceptance that the consequences, if you don't have a right to reside there because you hadn't registered, here because you hadn't even worked, are proportionate. Your Lordship, I'll come back to my Lady Hale in a moment. Your Lordship will see at paragraph 60, Lord Carswell, and he agreed with his noble and friend Lord Hope. Lord Brown, at paragraph 61, said, "My Lords, I've had the advantage of reading in draft the opinion of my noble and learned friend Lord Hope. For the reason which he gives, I too would dismiss the appeal and confirm the decision of the Social Security Commissioner. In deference to the contrary conclusions arrived at by my noble and learned friend Baroness Hale of Richmond, I add just the following paragraphs." And he says, "I accept. It's impossible not to feel a measure of sympathy. She was, after all, allowed to come and work here, and no one disputes that she completed, if only just the 12 months' work. Well, Mrs. Patmalniece, of course, has never done that. She's just come and now seeks to live off benefits." And then my Lord then goes on to deal with, is it then to be, paragraph 63, that this requirement to register, and more particularly the adverse consequences, that is, the loss of your right to reside status and the loss of access to social support, were disproportionate? To my mind, not. And then your Lordship says you can always think up a better scheme, but he comes to the conclusion that this scheme is proportionate. So three of your Lordships, I've now shown you, have accepted the legitimacy of the aims, accepted the proportionality of first registration, accepted the proportionality of re-registration, notwithstanding the consequences, which is to lose social support. If I could go back to my Lady Baroness Hale at paragraph 46. At paragraph 46, my lady summarises the arrangements.
Well, that's addressed to the first argument.
Yes, and then 47, I agree with Lord Hope that the measures taken were compatible with the authority given by the Treaty of Accession. I cannot, however, agree that they were compatible with the community principle of proportionality, and your Lordship then sets out the test. 48, one must therefore first establish the aim which the measure sought to achieve, and then ask whether the means used were suitable to achieve that aim, and then whether they were necessary in the sense that the adverse impact upon an interest worthy of protection was justified. It seems to me that proportionality must be judged not in relation to an aim which the measure might lawfully have had, but in relation to the aim that it actually did have. The fact that the United Kingdom could have imposed more extensive restrictions, in your Lordship's view, was irrelevant. We opened our doors from the outset, and so on. And the sanction at 48F, the sanction of depriving a worker who had been employed here for 12 months of the social benefits to which he would normally be entitled as a result of having joined the United Kingdom workforce, is neither suitable nor necessary for the achievement of that limited aim. In short, it is disproportionate. So all your Ladyship was dealing with was the disproportionality of the consequences arising from re-registration. I may not be able to say that your Ladyship went so far as to say the basic aim was okay and the basic requirement of registration was okay, because that wasn't an issue.
Well, you might get some help.
Oh, good. Oh, sorry.
From paragraph 53. Because in paragraph 53,
Yes.
I deal with the 12-month rule,
Yes.
which was aimed.
Yes.
Yes, your Ladyship does. Yes,
Yeah.
yes, absolutely.
And my point was simply that the registration scheme had a much more limited purpose, and deprivation of somebody who fulfilled the legitimate aim
was not right.
was not right and not proportionate.
Yeah, because of a paperwork problem, essentially.
Yes.
Because of the failure to register
Yeah.
the form in.
That
Particularly,
carries
your
down into
Ladyship.
55 as well,
Yes.
doesn't it?
Yes. So I think
Yes.
you probably are justified in saying that I agreed upon the legitimacy of the overall aim of preventing benefit tourism.
I am extremely grateful.
55, I think, is worth just glancing at that, because that's on the
Oh, yes,
same
as the monitoring
point.
is because the registration just gives you some sort of legitimate way to achieve it. Could have been better designed and so on. Yes, but yes, so I now have 4 on my side in terms of the basic legitimacy. I now turn with trepidation to Lord Newburger at paragraph 66. And he agrees with Lady Hale for the reasons given in paragraph 47 to 58, which include 53 and 55. Yes, and at paragraph 68, as Lady Hale says in the third line down, as Lady Hale says in paragraph 56 of her opinion, the outright denial of future benefits to a person who has worked here for 12 months is simply not a suitable means of achieving the primary aim of the system. So just pausing there, it does appear that there is a full house, if I may put it so inelegantly, for the basic principle being a legitimate principle, and indeed for the requirement of registration. So if somebody didn't register at all, if Mrs. Valeska had never registered, nobody would have, your Lordships wouldn't have criticised it. And the only issue of debate was it legitimate to go a bit further and require re-registration? To which the answer is 3 of you said yes, 2 of you said no. Now here we are dealing with an A8 national, Miss Patmalniece, who has never worked in the United Kingdom.
I think most
never
of us got
registered.
that particular point.
I may have mentioned that earlier, but that's the position there. But the key point is, in terms of analysis, the underlying aim is the social statement, the Secretary of State's statement that it's the prevention of the exploitation of benefits by those who come not to work but to live off benefits. That worked out in Ms. Zaleska's case and in Ms. Patmalniece's case by reference to the workers' registration schemes and when you had a right to reside, and the consequence was that you didn't have the benefits because you didn't have the right to reside. And in my submission, that is the second reason for concluding that the rule in this case is objectively justifiable, because your Lordships has accepted the basic aim as being objectively justifiable.
Let's turn to the third.
Yes,
chapter.
the third one was Troiani, because we say it's compatible with Troiani as well. But that, incidentally, that is just additional, my lord. We say it is compatible with Troiani, even if you're not, because for some reason there's something in Troiani. It's still compatible with the EU legislation and with Zaleska. But can I ask your lordships then to go to tab 79 for Troiani? My lord, as always with these cases and with restrictions of time, one tends to pick out sentences. But it is important for some cases, and I would say there are three, Bressol, Zaleska and Troiani, where your lordships need to go through the whole. So I trust you'll indulge me and allow me to take you through the whole.
Sorry, Mr. Lewis, you're not going to read everything out, are
No.
you?
But I'm going to show you the structure and I'm going to show you some key paragraphs.
Yeah.
Could I start at page 825? And you'll see the facts, because it's what my Lord Brown said yesterday. The key thing about Troiani is that in the nick of time, he got a residence permit. AG3, he'd registered at the Commune of Brussels and had a temporary registration certificate covering his period of residence from the 8th of April to September the 7th, 2002. The National Court was not provided with any information concerning Mr. Troiani's resident status after September the 7th, 2002. But he himself has told the Court of Justice that he now has a 5-year temporary residence permit. That is what had happened between the reference and the Court of Justice. He got, under national law, a 5-year grant of residence. Then 5 and 6 summarises the questions, and I will ask you to look at AG 8. Finally, the Commission has proposed in these proceedings that the questions referred by the National Court be reformulated inasmuch as the main point of issue is whether Mr. Troiani is entitled to the minimum subsistence allowance, minimex, in Belgium. The main proceedings are not about obtaining a residence permit. I propose that the Court should reject the Commission's proposal. The questions posed by the National Court, did he have a right of residence, are of direct importance for the settlement of the central issue, inasmuch as the answer to the question whether Mr. Troiani has a right of residence under community law, and if so which, will determine whether he's entitled to the minimex. That's the whole point. If he had a right of residence, he would have got it. So by saying they don't have a right of residence under community law, that means it wouldn't follow that you could rely on those particular provisions of community law. It turned out there were other ones in issue, as we'll see. Then your Lordship sees the basis of analysis starting at AG 9 and AG 10. And you'll see at little b at 10 that Commission law recognises as a ground for limiting the right of residence, preventing any unreasonable burden being placed on the public finances. Over the page AG 13, he elaborates on B. Community law recognises two categories of legitimate interest. One is the public order, public safety, public health. The other is limitations intended to prevent unreasonable reliance. And it's this second category that plays a leading role in Troiani, question of establishing the conditions under which member states may limit the right of residence. AG 17 and 18 are important. AG 17, in my opinion, the differential treatment of economic and non-economic migrants viewed historically is based on a fundamental difference in approach. In order to establish the common market, it was necessary first to remove obstacles to interstate trade, including those relating to the labour factor. Only later was the free movement of persons to develop into a fundamental right of every citizen of the European Union. The difference in treatment now has a mainly pragmatic basis. So long as social security systems have not been harmonised in terms of the level of benefits, there remains the risk of social tourism, i.e. moving to a member state with a more congenial social security environment, and that is certainly not the intention of the EC Treaty, which to a considerable extent leaves responsibility for social policy in the hands of the member state. The community legislature has acted on the assumption that an economic migrant will not claim any subsistence allowance in the host member state. Article 7 of the Regulation 1612 grants the migrant worker rights primarily in respect of conditions of employment and, moreover, social advantages that facilitate his stay, such as, for example, assistance with education for his children, and so on. Then, my Lord, I was going to move on to paragraph AG 63, you'll be glad to hear, quite a leap. we don't have to deal with the first question, which is whether or not somebody doing the kind of cleaning the hostel for the Salvation Army made him a worker. We're on to the second question. In order to answer the National Court's second question, it would be necessary to interpret the fundamental right of European citizens under Article 18. And AG 63 has already mentioned Directive 90/364. That's the one that says you can come if you have sufficient resources, authorises the Member States to refuse the right of residence to citizens of the European Union who do not have sufficient resources. Thus, the provision of the directives constitutes a limitation laid down by the EC Treaty or by measures adopted to give effect to it on the right of residence within the meaning of Article 18. All the Member States that have intervened said Mr Troiani can't derive any right to reside in Belgium from Article 18. Mr Troiani took the different view. Then I'll move on to 66. This brings me to my answer proper, which consists of 2 points. First, it must be established whether in the given circumstances one of the limitations or conditions apply. And secondly, the application of this limitation or condition must be consistent with proportionality. As far as the first point is concerned, there can be no doubt Mr Troiani does not have sufficient resources to provide for himself. It is for precisely this reason that he is applying to the Belgian authorities for the minimex. Accordingly, he falls under the limitation mentioned in the directive, and he referred to the second paragraph. And then AG 68, the second point concerns proportionality. In accordance with the settled case law of the National Court, compliance means necessary and appropriate to attain the objective. National measures that limit the right of residence cannot be disproportionate, and it deals with bound-bast. 69, need a compelling interest to justify limits. And then 70, what then does this imply as far as the present case is concerned? It is clear that Mr Troiani cannot provide for himself, since he is applying for social assistance in Belgium. Denial of the right of residence is not disproportionate, since the limitations and conditions for which Directive 93/64 provides are intended to cover precisely persons such as Mr Troiani, who, for at least a substantial part of their income, depend on social assistance in the host member state. And the basic principle of community law is that persons who depend on social assistance will be taken care of in their own member state. And that's what he says.
It's that last sentence, of course, which is so fiercely contested by the appellant term.
Yes.
And
let me say,
he doesn't actually give authority for that, does he?
no, but it is simply the natural consequence of the EU legislation. If you have a right to reside, if you have sufficient resources, that reflects the fact that if you don't have sufficient resources, you won't have a right to reside. And therefore you won't be going to another member state. You will be looked after under whatever system is in place in your own member state. That is the consequence of not having a right to reside. If you were a worker or one of the other many categories, you would have a right to reside, and then you'd have access to social assistance. But when you aren't in that category, you'll be looked after by whatever system is in place in your country. Mrs. Patmalniece is in that position. She doesn't have a right to reside. She can bring her Latvian pension, and if she chooses, she can try and live off that. If she wants social assistance, she has to go back to Latvia because she will be taken care of under whatever is the system in Latvia. So that's the position under EU law. Now, what the Advocate General then deals with is 71. A final pertinent question is whether the way in which Mr Troiani was treated by the Belgian authority involved discrimination by reasons of nationality. And then 72 says, my views on this are as follows. He says, I note that rather Mr Troiani is present on the Belgian territory, this argument concerns the refusal to grant him an allowance. And then 73, the answer to the question whether the case involves prohibited discrimination depends on the right of residence status of the European citizen. If a citizen of the European Union derives his right of residence from community law, he will fall within the scope of community law, and in view of the prohibition on discrimination, may not be treated differently when applying for social assistance, and that was the G judgment which concerned the minimex. However, and this is where he differs from the court, even if a residence permit is issued purely on the basis of national law, as in the case of Troiani, there remains the possibility of prohibited discrimination on grounds of nationality. This might well have been the case if Mr Troiani had been granted indefinite leave to stay his residence would then have been comparable to that of a Belgian subject, and the refusal to grant an allowance would have been a consequence not of a difference in residence status, but of a difference in nationality. However, in the present case, no such permit, i.e. no indefinite leave to remain permit, was issued. If, on the other hand, as according to the file, and I've shown you paragraph 3, a temporary residence permit is issued, the union citizen concerned does not have the unconditional right. And where the court differed from the Advocate General was he did not regard the 5-year right under Belgian law as being enough. He said the European law doesn't give him the right, therefore the refusal of discrimination doesn't contravene that, the benefit doesn't contravene that part of community law. He said, is it changed because he's got a domestic law right? And he said, no, it would if it was indefinite leave to stay, but not if it's 5 years. And that's what the Advocate General said. And then if I can move to the judgment, and this will be much quicker. I know the judgment starts at page 838.
Yes, it's the second question we're looking at, isn't
Yes,
it? Paragraph
840,
30.
paragraph 12 gives you the questions,
Yeah.
if your Lordship wants at some stage to see the questions.
Yeah.
And then it's really, as your Lordship says, the second question, which starts at paragraph 30.
No, we've already
We've looked at some of it,
getting through this.
and I will do it as quickly as I can, my Lord. It is so important.
Yes.
If I rush it,
All right.
it will not be helpful. Paragraph 30, by its second question, the National Court is essentially asking whether, if he's not a worker, a person in the situation of the claimant may simply by being virtue of a citizen enjoy a right of residence. Then it says, right to reside conferred by Article 18. 32, the right is not unconditional, subject to limitations. 33, among those limitations and conditions, follows Article 1, allows member states to require the nationals of a member state who wish to enjoy the right to reside within their territory that they themselves and their members of the family have sickness insurance and have sufficient resources. 34, these requirements are proportional. 35, it follows from the judgment making the reference that a lack of resources was precisely the reason why he sought to receive a benefit such as the minimum X. In those circumstances, a citizen of the Union in a situation such as that of the claimant in the main proceedings does not derive from Article 18 the right to reside in the territory of the member state of which he is not a national for want of sufficient resources within the meaning of Directive 93/64. Nothing to suggest that that would be disproportionate. And what they are saying there is if that is where the case had stopped, he was not entitled to a right to reside under community law because he didn't have sufficient resources, and it would follow that he was also not entitled to insist on benefit, and Belgium would have been entitled to refuse him benefit. But then you go to paragraph 37.
Yes.
However, it must be observed that according to information put before the court, and this is what I drew your attention to, Mr. Troiani is lawfully resident in Belgium, as is attested by the residence permit which has in the meantime been issued to him. Then it says that it's for the court to provide the National Court with all the help it needs. And then 39, in the context of the present case, it should be examined more particularly whether, despite the conclusion in paragraph 36 above, i.e., even though he doesn't have a right under 18 and can't therefore get access via 18 to residency and benefit, whether despite that conclusion, a citizen of the Union in a situation such as that of the claimant, which is he's got a right to reside under Belgium law as attested by the permit, whether a citizen of the Union in a situation such as that of the claimant may rely on Article 12, which prohibits discrimination. 40. In the present case, it must be stated that while the member state may make residence of a citizen of the Union who is not economically active conditional on his having sufficient resources, that does not mean that such a person cannot, during his lawful residence in the host member state, benefit from the fundamental principle of equal treatment. I.e., because he was lawfully resident in Belgium, he'd been allowed to reside in Belgium for 5 years as evidenced by the permit. During the period of that residence, Article 12 would apply.
But isn't our appellant lawfully resident here? You said she's not unlawfully resident.
No, my lord, I have said present, not resident. Lawfully resident means entitled to reside under the laws of the state. She has no right under the laws of the United Kingdom. She was refused asylum. She has not been granted indefinite leave. She is present in the United Kingdom. She's liable to removal, but she is simply present here. It is not unlawful. She's not committing a criminal offence, but she is not lawfully resident. Reside and lawfully means reside under the laws of the state. Has
She's
a right.
habitually resident. That's a concession. That's a given in the case.
Yes, she's habitually resident, which means, when we concede that she has all those factual characteristics which show that she's habitually resident in state. As a matter of fact, she's got nowhere else to go. She's got no family anywhere else. The centre of her interests are now in the United Kingdom, and she's not, if she can help it, going to move anywhere else. So this is, in inverted commas, where she wants to be. Is she lawfully resident? No, she is not. Because she is not exercising any right to reside under the laws of the European Union or the laws of the United Kingdom. She would be if she applied for and were granted indefinite leave, but she was refused that, or some other method.
So paragraph 31 of the Statement of Facts and Issues does use the phrase habitually resident.
A bit for the purposes of Regulation 2.1, meets that part of the test that deals with factual. The habitual residence has got two parts. You've got to have the right to reside as a matter of law, and then you have to be habitually resident. The United Kingdom national coming from 20 years in Hong Kong would have the right to reside, but would not be habitually resident because his centre of interest wasn't in the UK. She would also have a right to reside if she was a qualified person such as a worker. But she's not lawfully present. I'm going to show your lordships in a moment Abdurrahman, which says the difference between presence and residence, and lawful presence and residence. But can I just, in order to make some kind of order,
Yes, all right.
go through the rest of Troiani?
Yes, I'm sorry.
We haven't looked at the relevant part of that. 41, in that connection, 3 points. It's not my fault, because it's not for the heckle. Paragraph 41 says, in this connection, 3 points should be made. 42 is the court has held a social assistance benefit such as the minimum effects falls within the scope of the treaty. Secondly, with regard to such benefits, the citizen of the Union who is not economically active may rely on Article 12 where he has been lawfully resident in the host member state for a certain time or possesses a resident permit, i.e., like Mr. Troiani, who has a right under national law attested by the residence permit. And then, thirdly, national legislation such as that in issue in the naming proceedings, insofar as it does not grant the social assistance benefit to citizens of the European Union who reside there lawfully, even though they satisfy the conditions required of nationals of that member state, constitutes discrimination. It should be added that it remains open to the host member state to take the view that a national of another member state who has recourse to social assistance no longer fulfills the condition of his right of residence, and he may be removed within the limits of community law, but that can't be automatic. The one paragraph we haven't read is the one over the page, which is very important. Consequently, the answer to the second question must be that a citizen of the Union who does not enjoy a right of residence in the host member state under Articles 39, 43 or 49 EC may, simply as a citizen of the Union, enjoy a right of residence there by direct application of Article 18. The exercise of that right is subject to the limitations and conditions referred to in that provision, but the competent authorities must ensure that those limitations and conditions are applied in compliance with the general principles of community law, in particular the principle of proportionality. However, once it is ascertained that a person in a situation such as that of the claimant in the main proceedings is in possession of a residence permit, he may rely on Article 12 in order to be granted a social assistance benefit such as the Minimex. And that is the point. He didn't have it under EU law simpliciter because he didn't have sufficient resources. He could be denied the right of residence, and it wouldn't be unlawful on that ground alone to refuse him the social assistance benefit. However, once it's ascertained that he actually has the residence permit, he's been given the right under national law in Belgium, then during the currency of that residence permit, Article 12 applies, and he can't be treated differently from a national. So if a national got it, he, as somebody residing under domestic law, would also get it. And that is why what my Lord Brown said yesterday is correct. As Lord Justice Moses put it, in the nick of time, he got a residence permit, and therefore he had a national law right to reside, and therefore Article 12 prohibited discrimination between them. But our regulations allow for that. If you have a right under EU law or a right under domestic law to reside, i.e. a right granted by EU law or a right granted under the national law to reside, then during the currency of that lawful residence you will have equal treatment. So Miss Patmalniece came, she applied for indefinite leave to remain, I imagine, on the basis of the convention, and she was refused. And she has not been granted a domestic law right and does not have the economic and social integration for an EU law right. Can I just ask your lordships to look at Abderrahman, which confirms this, and it was followed in Kazmarech. It was followed in Kazmarech, and hasn't been challenged by the appellant, but the appellant isn't saying, as I understand it, that Abderrahman and Kazmarech is wrong. He's distinguishing them. It's Mr. Drummond who'd like to say, except in this case he can't do it here, but he's saying, if I ever get a chance anywhere else, I'd like to do it. And Abderrahman is in volume 2, tab 29. Yeah, okay.
No.
Yes, 229.
It is.
29 of volume 2. Abderrahman?
29, yes. Sorry, I thought it said 39.
The claimant in each case, do your lordships?
Well, I think we do have it.
Yep.
Don't have it.
Yeah,
Yes,
no,
yes,
sorry, I
yes.
thought it said 39. I got it.
The claimant in each case was a European Economic Area national who was lawfully present in the United Kingdom but not working and not economically self-sufficient. The first wanted income support, housing benefit and council tax, and the second claimant wanted state pension credit. All the claims were refused. And then on the claims appeal, dismissing the appeals, one, that there was a distinction in United Kingdom law between a right to reside and lawful presence. That although a European Economic Area national who was a qualified person within the meaning of Regulation 5.1 of the 2000 regulations had a right to reside conferred upon him pursuant to Regulation 14, such a right did not extend to a European Economic Area national who was not a qualified person. And then they dealt with another convention and said that didn't apply, and that accordingly, just above letter B, although the claimants were lawfully present in the United Kingdom, they did not have at the relevant time a right to reside for the purposes of the various relevant benefit regulations. And if your lordships go to paragraph 19, it may assist your lordship to have open in volume 1 the regulations at tab 6 of volume 1 at the same time as we look at this case. So you will better appreciate what the Court of Appeal is talking about. Does your lordship and your ladyship have those regulations?
That's
Could I ask you to go to...
2326, is it?
Yes.
SI 2326 of 2000.
Yes, the 2000 immigration regulations, the ones in force at the time. Could I ask your lordship to go to Regulation 14.14?
Yes.
And this is the right of residence, my lord. Your lordship is asking what a right of residence was. This is 14, right of residence. A qualified person is entitled to reside in the United Kingdom without the requirement for leave to remain for as long as he remains a qualified person. And then you've got family members and so on. And to discover who is a qualified person, my lord, you have to go back to 5. Could I ask your lordship to go back to 5?
No.
It will be a list that is now familiar to your lordship. It's a worker, a self-employed person, provider of services, a recipient of services, a self-sufficient person, a retired person, a student, a self-employed person who ceased activity, 2, you don't cease to be qualified because you're temporarily incapable, you're involuntarily unemployed, and so on. So all of these people are people who have a right to reside, and she simply isn't one of them, my lord. She doesn't have a right to reside. And then going to Abdirahman, paragraph 19, it seems to me plain that UK law makes a distinction between a right to reside, which is conferred only on British citizens, certain Commonwealth citizens, and qualified persons as defined by the Immigration Regulations 2000, and the various additional categories mentioned in the definition of persons from abroad, such as refugees, those with indefinite leave to remain, and those to whom exceptional leave to remain has been granted on the one hand, and any lesser status, in particular that of an EEA national who is in this country, having entered lawfully, has committed no breach of immigration law, but is not a qualified person and therefore does not enjoy the benefit of Regulation 14, which confers a right to reside. So that is the answer to my Lord's question. A right to reside derives from the 2000 regulations or categories such as indefinite leave to remain for refugees and so on, but it doesn't include people who've entered lawfully, committed no breach of immigration, but aren't qualified. And we are talking about such people. Mrs. Patmalniece is such a person, and the policy applies to such people, because if they were workers and so on, then they'd be qualified persons anyway under the regulation. And then, if your Lordship just go to one last paragraph in this, 44, I accept Mr. Say's proposition that the European cases show, this is Troiani and Martina Salas and all the others, the scope of, because they dealt with it, paragraph 32, the scope of application of the treaty for the purposes of Article 12 EC includes both cases where a right of residence arises directly under the treaty and those where it arises separately under the law of the member state. It does not extend to cases where no right of residence exists under either the treaty or the relevant domestic law. So, the next paragraph has been read.
Can you read the first 4 lines of paragraph 43?
I'm asked to read the first 4 lines of paragraph 43 by the intervener, not the appellant. The claimants complain of discrimination as regards entitlement to social security benefits. Such benefits themselves are not within the scope of application of the treaty. The criterion used by the UK legislation in this respect is whether the claimant does have or does not have a right of residence. Then, yes, and then my friend Mr. Koppel reminds me that Kazmarek said that the word not in 43 was actually a misprint, and it shouldn't be there. And it shouldn't be there.
Oh,
Which were?
is that in the second?
In the second line, such benefits themselves are not, because they are within the scope of application of the treaty.
That's the point.
And then Kazmarek says that that must be a mistake.
It's quite important.
But I'm not going to I've got limited time, and I'm not going to make further arguments on behalf of the intervener. He's had his hour, and I'm going to try and keep a proper shape and focus,
All right,
which is to look at Troiani and to say, where does Troiani fit in the scheme of things? Does it assist us or does it not assist us? And we say, firstly, for the 2 reasons I've already given, the regulations in the UK are lawful. Secondly, I'm saying they're consistent with Troiani, because Troiani recognises that if you don't have a right under EU law or domestic law to reside, you don't get access to benefits. If you do have a right under EU law or domestic law, then you can't differentiate between nationals and non-nationals. And this policy deals with those people who do not have rights under EU law or domestic law to reside, and therefore, if they don't qualify, as the Advocate General recognises in paragraph 70, the consequences will be that they will have to be looked after if they need social assistance in their own state. So it is the third and additional reason why we say the rules are objectively justifiable. They're objectively justifiable because they're based on economic and social integration, full stop. It is consistent with EU law. It has been upheld by a robust 5-person House of Lords in Zaleska. And, if it's helpful and relevant, is consistent with Troiani. I ought just to mention Martina Salas, just so your Lordship knows what the answer is to Martina Salas. Martina Salas was also simple. She had a right under domestic law, but the Germans wouldn't give her the paperwork to prove it. And
wouldn't do what?
Wouldn't give her the paperwork to prove it. She had the right, they wouldn't issue the permit, and they said you can't get the benefit you want unless you actually got the paperwork. And I can show your Lordship 3 paragraphs. If you take up Martina Sala...
Is this tab 71 in volume 6?
It certainly is, my Lord.
Yeah.
If you go, it's really always helpful just to look at the facts rather than diving into a paragraph. Could I ask you, Lord, to go to 2702?
Yeah.
If you go about 5 lines from the bottom, the National Court itself informs us that the plaintiff is a community national.
Sorry, Clive, would you read from the beginning of the paragraph?
I'll read from it all. My friend would have had a right to reply, but I'll read from it all. The facts of the case have been described above. We do not know why the special residence permit required under German law for the grant of child-raising allowance is now being denied to the plaintiff. She was issued with a permit for certain periods during her long stay in Germany. Nor do we know whether the special residence permit, which after all is the only one relevant in this case, may be and is in fact issued to community citizens who, according to an unpronounceable thing, are included in the category of foreigners, even if the requirements laid down in Directive 93/64 regarding the residence permit and the related right of residence are not fulfilled. The National Court itself informs us that the plaintiff is a community national authorised to reside in Germany. The German government, however, points out that this is solely by virtue of national legislation. Mrs. Martina Salas does not fulfil the conditions conferring a right of residence under the directive. So the German government is telling us that it's solely national legislation. You then go to the judgment at page 2714, and you'll see at paragraph 13 that Mrs. Sala was born on the 8th of February 1956. She'd lived in Germany since May 1968, that is since the age of 12. She'd had various jobs at intervals between 76 and 86 and was in employment. And then at 14, until 19th of May 1984, she obtained from the various competent authorities residence permits, which ran more or less without interruption. Thereafter, she obtained only documents certifying that the extension of her residence permit had been applied for. And in its author reference, the court points out that the convention didn't allow her to be deported, and then a residence permit expiring on the 18th of April 1995 was issued to her on the 19th of April 1994, and that lasted for another year. But it was in the in-between period when she wasn't issued with a permit, just issued with a document saying that she'd applied for an extension, that she was refused a residence permit. So it's clear that she was entitled under national law, and she's got the permit, and then they say only that she's applied for it, and then they give it to her again. And if you look at paragraph 16, it says, Freistaat Bayern rejected her application on the grounds that she did not have German nationality, a residence entitlement, or a residence permit. And then by judgment on the 21st of March 1994, the Social Court dismissed an action against the decision on the ground that she was not in possession of a residence permit. That was the only thing that she lacked by that stage. And then if you go to the paragraph that my friend showed you yesterday, page 2722, paragraph 46, by its fourth question, the referring court seeks to ascertain whether community law precludes a member state from requiring nationals of other member states to produce a formal residence permit in order to receive a child-raising allowance. This question is based on the assumption that the appellant in the main proceedings has been authorised to reside in the member state concerned, and I've just taken you through that. Then 48 describes the German law, permanent or ordinarily resident in German territory. 49, a national of another member state who is authorised to reside in German territory and who does reside there meets this condition. However, 50, the law provides that unlike German nationals, a non-national, including a national of another member state, must be in possession of a certain type of residence permit in order to receive the benefit in question. And it is common ground that a document merely certifying that an application for a residence permit has been made is not sufficient, even though such a certificate warrants that the person concerned is entitled to stay. And 52 points out that that's really just a paperwork thing and it's disproportionate, and they go on to find that that was unlawful. So Martina Sala is exactly the same thing as Troiani. You have a right to reside under national law. They'd given her the paperwork before, they'd given her the paperwork afterwards. The German government confirmed she was only entitled under national law. But what they did was apply to non-Germans only a requirement that they have the right piece of paper. And that was, not surprisingly, not lawful. So that's all that Martina Sala says. There is no magic, with the greatest respect to Mr. Cox, in these discussions about the scope of Article 3 or the scope of Article 12 or any of the other points that he's made. It really is, with respect to him, a very much simpler case. There is a rule that says you must have economic and social integration, and that applies across the board to everyone. We say that is objectively justifiable for the reasons that we've given, and Mr. Cox says it's not. It's objectively justifiable, full stop, and is consistent with EU legislation. That's definitely right, because it's accepted as such in Zaleska, full stop. If you wanted a triple check, it's consistent with Troiani and Martina Sala.
Well, thank you very much. That's the end of that chapter, is it?
Yes. 2 brief points about the intervener's case. He says in paragraph 10 and 14 of his case, and this is the last point I need to make, and then I can move on to the Irish. At paragraph 10 and 14, he says that the contention is that the 2004 directive implies that people who have exercised the right of evidence, the right of residence, but is in financial difficulty will be entitled to social assistance. That's paragraph 10 of his case. Does your Lordship see that?
Yes.
And in paragraph 14, the central point is that the scheme of the directive, the 2004 directive, and in particular 14 therein, assumes that an EU national who has exercised the rights of residence provided by it will have an automatic ability to access social assistance benefits. First, this case is not about Directive 2004-38. It wasn't due to be implemented by the relevant date. It was due to be implemented by April 2006 and was. We are dealing with the earlier directives, 9364 and 9365 on pensioners, and there is nothing in those regulations which suggests that somebody who lacks resources, in fact, gets resources. Secondly, the interveners are concerned with people who've come to the UK in the exercise of rights to reside, and then they encounter temporary difficulties. That is not the group of people whom this appeal, this statutory appeal from the Social Security Commissioners is concerned with. We are dealing with people such as Miss Patmalniece, who've never exercised the right to reside.
I mean, do you accept, therefore, a different situation might arise in the case of those who have been here but have lost that right?
No, we don't. For different reasons, we say that too would be acceptable. But can I just go through the 3 stages in a moment? I'll come back to my Lord's question in just a minute. One, the central thrust of their case is built on Directive 2004-36. It wasn't, 38. It wasn't the relevant directive in force at the time. Secondly, the group that they're concerned with, people who've exercised their right to reside and then encounter temporary difficulties.
Sorry, could you say that again? I didn't quite catch it.
Secondly, the group that the interveners are concerned with are people who have exercised their right to reside and then encounter temporary difficulty. Yes. And we say that's not this group, it's not Miss Patmalniece. The third issue is the issue that my Lord, Lord Simon Brown has just raised, and the answer to that requires you to look at paragraph, tab 26.
1 and 2.
Of volume 1.
No. Yes, volume 1, yeah.
Because the answer to the point, my lord, is that the directive itself tells you who can and cannot stay, even if they have temporary residence, even if they have temporary difficulties. And people who aren't allowed to stay, like Mrs. Kazmarich, would be in the position of people who are in this country, voluntarily unemployed, not seeking to work, but seeking to live off benefits. If you look, my lords, at Article 7, right of residence for more than 3 months, does your lordship see Article 7?
Yes.
Article 7.1 gives the right of residence to workers, those with sufficient resources, and students with sufficient resources. If your lordship goes over the page, 7.3, for the purposes of paragraph 1a, a union citizen who is no longer a worker or self-employed shall retain the status of worker if he is temporarily unable to work as a result of illness or accident, is in involuntary unemployment after having been employed for more than 1 year, is in involuntary employment having worked for less than 1 year. My lord, those people will have rights to reside. They've exercised their rights to come here. They are the people...
I'm so sorry, would you just read to the end of 3C?
Sorry,
I'm so sorry.
Mr. Lawson, I don't
I'm
pick it up.
conscious of time.
Yes, I know.
And I'm trying to move on, and it's not helpful to be deflected, but I'll read it all. It'll be quicker. He is duly recorded involuntary unemployment after completing a fixed-term employment contract of less than a year or after having becoming involuntary unemployed during the first 12 months and is registered as a job seeker with the relevant employment office. In this case, the status of worker should be retained for no less than 6 months. A is temporarily unable to work, illness. B is involuntary employment, you've been there for a year. 3 is involuntary employment, you've been there less than a year, and then you get another 6 months.
Yeah.
D is vocational training. The detail isn't the point. The point is this, that those are the people who have exercised their rights of residence and have run into temporary difficulties, that the directive says retain their status, will be entitled to reside and will qualify for benefits. People who come to work but then become voluntarily unemployed are not people who have their status protected. They're not people who've encountered temporary difficulties in 7.3 terms. They are people who have chosen to remain unemployed. And they then fall into the category of people who are in this country not to work, but to live off benefits. And they don't qualify because the policy applies to them and is equally proportionate, because the community recognises that it is right to assist those in temporary difficulty if it's illness or involuntary unemployment. But if you come never intending to work, with Mrs. Patmalniece, if you come, you work for a little while and then you say, well, I'm sorry, I'm not going to work anymore now, I'm going to claim benefit, then you are also in the group of people who are in this country not seeking to work but to live off benefits. And that will be the third category. But we're not in that category here. So we say it would be justified, but it doesn't actually fall for decision in this case. Because one, we're not into this directive. Two, Mrs. Patmalniece is in the group of people who have never exercised rights to reside under the treaty. Furthermore, your Lord, just so that your Lordship knows, 12 and 13 of this directive that we're still in gives other people the right to reside. Family members after the death or departure from the United Kingdom of the Union citizen, they can stay here, but they can't acquire permanent residence until they work or have sufficient resources, so they have a right to reside. Article 13 also protects the right of those people who get into difficulty because they are divorced. But again, they can't get permanent residence. And my lord, if you look at 14, that is the retention of the right of residence. 1, they keep it under Article 6 so long as they're not an unreasonable burden. 2, they keep it so long as they have the right of residence, provided for in 7, 12 and 13. And then 3 is an expulsion measure shall not be the automatic consequence. In our submission, the directive is not dealing with the creation of rights to social assistance. It is a directive about residence. It tells you who can stay and in what circumstances. It tells you if somebody loses the right to reside, say they lose the ability to be self-sufficient, their grant is taken away by the German authorities, you can't the very same day automatically remove them. But the directive is not concerned with and does not grant rights of social assistance. That is left to the member states concerned. My lord, those are my submissions on the second and real issue, which is objective justification. I'm now moving to Ireland, unless your lordship has any outstanding questions in relation to the second area.
No, I don't think we do.
It's complicated.
Just to get our bearings on the Court of Appeal, you'll help us, will you, in how the Court of Appeal deal with this in paragraph 54?
Yes. With Ireland or with...
With Ireland.
Yes, I will, my lord, yes.
It's fairly brief. I think it's 54.
Yeah.
Yes.
There are... For your lordship's note, your lordship needs to read, but I'm not going to take you to it, Flea A, which is at page 111 of the appendix, paragraphs 22 to 34, which sets out the factual reasons why Ireland is in a different position. And there are 4 questions, my lord. May I just list the questions and may I then make my assertions and back them with submissions?
Yes.
The 4 questions are, does the fact that different arrangements are made for Ireland undermine the policy justification in relation to the other 25 member states?
Sorry, made for Ireland, does it do what?
Does it undermine the policy justification in relation to the other 25 member states? It said, oh look, you want to protect the British Exchequer from people coming here and claiming benefits instead of working, but you're letting the Irish in. If you do that, why aren't you letting the Latvians in? That, in colloquial man-in-the-pub language, is what is being put against me. Does the position in relation to Ireland undermine the policy justification? Secondly, is it within the protocol, permitted by the protocol? Thirdly, if it's not within the protocol, is it unlawful because it's direct or indirect discrimination that's not objectively justified? Fourthly, if it is unlawful to give the Irish this treatment, what do you do about it? Do you sever the illegality from the regulations because it's unlawful to give the treatment to the Irish? Or do you have to give the treatment to all other 25 member states as well? So it's justification, discrimination, justification, protocol, discrimination, and severance. Dealing with the policy justification first, this
is 3, is it?
No, policy justification, protocol, justification...
I know, sorry, I'm sorry. So, you're going to question 1, right?
Yeah, question 1, does the treatment of the Irish undermine the policy justification? How can you say you're protecting the British Exchequer by stopping people coming to work in the UK, by coming to claim benefits in the UK if they don't work, when you let the Irish come in and they can benefit? And the short answer is that for economic, social and historic reasons, the position in relation to the Republic of Ireland is simply different from the position in relation to the other 25 countries stretching from the Baltic to the Mediterranean, for the reasons given in Flea. And therefore, recognising the differences between the United Kingdom and Ireland on the one hand and the rest of Europe on the other hand does not undermine or invalidate a policy justification that applies to the rest of Europe. The other 25 member states are simply not in the same position, and we are entitled to say, well, we will put the UK together with Ireland on the one hand when we're working out this policy because of the economic, social and cultural and historic ties between us, but of course that position isn't true of Bulgaria or Romania or wherever else you want to think of. So it is not the case to say, because we've done it for one group, for one specific set of reasons, it therefore invalidates what we have done in relation to other groups. Turning next to the protocol, which is at tab 12 of volume 1. No, it's not, it's tab 11 of volume 1.
Yes.
This is part of the treaty and it is annexed to the treaty. As a protocol, it is part of and has the same status as the treaty. If your Lordship looks at Article 2, first sentence...
You're moving too fast. Treaty of what?
This was, it's currently the
Amsterdam.
Treaty on the Functioning of the European Union. It was annexed, I think, to the Treaty of Amsterdam.
Yes.
Was it the Treaty of Amsterdam? Oh, yes. If your Lordship looks at this title, my friend Mr. Coppell helpfully points out, it's a protocol annexed
The 1997 treaty.
on the application of certain aspects of Article 14 of the treaty establishing the European Community, what is now the Treaty of the Functioning of the European Union. It was brought in by the Treaty of Amsterdam. And if you look at the fourth bullet point down on page 1, you'll see, having agreed upon the following provisions, which shall be annexed to the treaty establishing the European Community and to the Treaty on European Union. Does your Lordship see that?
Yes, I do.
So it's part of the what we used to call the EC Treaty, we now call it the Treaty of Lisbon. It was brought in by Amsterdam, but it's basically an annex to the Constitutional Treaty of the European Union. And it's part of and has the same status. Turning over the page to Article 2,
Yeah.
what this allows the United Kingdom and Ireland to do, because of its particular circumstances, the United Kingdom and Ireland may continue to make arrangements between themselves relating to the movement of persons between their territories. First, these arrangements do relate to the free movement of persons between the territories of Ireland and the United Kingdom. They facilitate free movement in that people don't cease to be eligible for support if they seek to move from Ireland to the United Kingdom. It relates to free movement because it facilitates it, because you can move to the United Kingdom and you will be able to claim state pension credit if you meet the other requirements.
Does it matter that some people don't actually move?
No, it doesn't. Because the second point I was going to make, my Lord, was this. The protocol is not limited to those who are economically active. It can apply to the economically inactive, the retired Irish whose grandchildren are living here. Because it is free movement of persons between their territories. It is not intended or limited solely to free movement of workers. It is free movement of persons between their territories. And these are arrangements relating to free movement of persons. They facilitate people being able to move from Ireland to the UK. Next, my friend says, well, this is not an arrangement between Ireland and the United Kingdom because there's no reciprocity. Mm-hmm. First, reciprocity is not the requirement of an arrangement. Two people can arrange something for the benefit of one of them. And I gave your Lordship the example yesterday. I can arrange to give your Lordship lunch. There is an arrangement relating to lunch. I may hope it is reciprocated, but it doesn't cease to be an arrangement because it is not. So reciprocity is not a requirement. Next, there is in fact, if your Lordship needs it, reciprocity and that's in volume 1, tab 28. Your Lordships may remember paragraph 246 of the Irish law. For the purpose of each provision of this Act, specified in subsection 3, it shall be presumed, unless the contrary is shown, that a person is not habitually resident in the state at the date of the making of the application, unless the person has been present in the state for a continuous period of 2 years. They've got different rules, or they had different rules at the relevant time. And if you're dealing with habitual residence, there are a number of factors. It's where your centre of interests are, your home, your husband, wife or partner, where your children go to school and so on. It's also where you intend to live in the future. The person who has lived in Ireland for 20 years and goes into the benefit office and says, excuse me, I'd like some benefit. And they'll say, oh yes, you've been here 20 years. Of course, we presume, therefore, that you're habitually resident in Ireland. And he says, oh, you might like to know, I've got a flight tomorrow morning to Australia because I've had enough. I can't stand the weather, I can't stand the economy, I'm going. That person would not be habitually resident because he had the intention of severing his ties and relocating elsewhere. He might have met a Polish bride and be off to Warsaw, and he might be terribly excited. But he would have ceased to be habitually resident. And that's why it's a presumption. And my friends seem to be making something of the fact that it's a presumption. It's a presumption because there are other factors that you might have to know about the individual. But there is a reciprocity of treatment because you make the same presumption for people residing in the common travel area as you do for people residing in Ireland. And you say, well, you're all right if you've been residing in the UK, but if you're off to Australia or if you're heading off for a Ukrainian husband or partner or wife, then you've ceased to reside, you cease to be habitually resident because the presumption is rebutted. So that's the criticisms of the protocol. Oh no, then my friend says, well, it doesn't affect any arrangement. Giving the Latvians the benefit, he says, does not affect any right, going back to the protocol under 11. Well, let's just have a look at the protocol, my lord. Firstly, the United Kingdom and Ireland may continue to make arrangements between themselves relating to the movement of persons between the territories. Well, that is exactly what these arrangements do. We're entitled to make arrangements relating to the movement of persons between their territories. It's inherent that people moving from Ireland to the United Kingdom may benefit from those. They may be Irish nationals, there may be other people with the right to reside in Ireland. But the very first sentence of Article 2 allows us, it's inherent in it, that there will be different arrangements for those who have a right to reside in Ireland. And secondly, to say that we can't make arrangements for Ireland without also making the same arrangements for all 25 countries is in reality to affect the arrangements. This is intended to allow us to have arrangements for Ireland, but under the claimant's analysis, that ability is being affected because we can't make arrangements relating to the free movement of persons between Ireland and the United Kingdom unless we also do it for free movement on the same terms with all other 25 member states as well. And thirdly, it does affect the arrangements for Ireland. It makes them unlawful, according to my friend's situation. They've either got to be removed or they have to be extended to everybody else. So it does affect them.
I haven't really grasped that last point, Miss Lewis. I'm sorry, it's my fault.
Does it affect arrangements between people moving between the United Kingdom and Ireland? If my friend is right, the answer is yes, because it's unlawful to do that.
Yes, I see.
And you must either solve that illegality by removing the right or by extending it to others. So it does affect them. Affect is a word that doesn't just mean adversely or prejudicially. Affect, alter, change. Not make it possible to do what 2 allows.
So where's this concept of affecting come from?
The last sentence, nothing in Article 14 of the treaty establishing the EC or in any measure adopted under them, shall affect any such arrangements. And my friend is saying Article 3 of the regulation is a measure adopted under the treaty, but that doesn't affect the arrangements. You can still give the Irish residents the treatment. You just have to give it to the Latvians and the other 24 member states as well. And he's saying, therefore, it doesn't affect the arrangements. That's what my friend's case is on this, I understand. And I'm responding to his case, and I'm saying that's not right. Yes. It does affect it. Because the arrangements are affected, because they are rendered unlawful as they stand. You either have to remove them or extend them. Turning to the third issue, and I've almost finished, my lord, justification. If I'm wrong, and if it's not covered by the protocol, then you have a situation where the arrangements, the right to reside in Ireland, which is what we're talking about under the British regulations for state pension credit, are going to favour Irish nationals more than other nationals, because you're more likely to reside in Ireland than, if you're Irish, than if you're of another nationality. And therefore the right to reside in Ireland is indirect discrimination, which is more likely to help the Irish national than it is to affect other nationals. And that is indirect discrimination in the way that we discussed yesterday, but we say it is objectively justifiable for the reasons given in Flay, the statement of the woman whom I can't pronounce, at paragraphs 22 to 34, starting at page 111, and I'll give your lordship the reference in the Court of Appeal in Couronne.
Sorry, could you give the bundle
Flea
reference number to Flay?
It's in the appendix, part 1.
Oh, sorry.
Page. It's a lady. It's not a case.
Oh, I'm so sorry.
It's a witness statement
Oh, yes.
that was put in other proceedings.
Yes.
Yes,
In
so
the Couronne proceedings.
Yes. So
And I don't want to take your lordship's time in reading it, but if your lordship goes to page 111, your lordship has to start at 22, and if your lordship would be kind enough to go to the end of 34 at page 117, that explains the reasons for having it. And then if your lordship were to go to the Court of Appeal case of Couronne, Courone, at tab 36, at paragraph 68 to 77, in volume 7, that says why the treatment of the Irish residents is lawful. I've just...
paragraph numbers again.
Volume 2, paragraph 36, paragraph numbers 68 to 77.
Where's Quran again, Mr.
Volume 2,
36.
tab 36, paragraph 68 to 77. And can I just take you to 69? On page 2786, you read it, I think, on Monday, my lord.
Yes, we've
Yes,
seen
we
it.
did.
Yes.
And that's the justification. So just pausing, where am I at the moment? I've answered 3 of my issues. The fact we have spent, I will be slightly more than the lunch hour.
I don't think you need worry too much. Just carry on.
Where am I in my 4 issues on the Irish?
Yes.
Does the fact that we have arrangements relating to residents in the Republic of Ireland in the British state pension credit regulations undermine the policy? No, because there are special reasons why Ireland is in a different position from the other 25 member states. Is it anyway preserved by the protocol? Answer yes, for the reasons I've given. If it is not preserved by the protocol, what is the consequence? The consequence is that having more favourable treatment for people who reside in Ireland as compared to nationals who reside in other member states is likely to be more favourable to Irish people than other people. But it's not direct discrimination, it's indirect discrimination, because there will be other people, other EU nationals who do have the right to reside in Ireland, and that is objectively justifiable for the reasons given in Couronne. And then fourthly, if all of that is wrong, and if it is just plain and lawful to make provision for residents in Ireland, what is the consequence? And can I ask your lordships to have open, firstly, the regulations in tab 9, And you will see the problem is, subject to paragraph 2, a person is to be treated as not in Great Britain if he is not habitually resident in the United Kingdom, the Channel Islands, the Isle of Man, or the Republic of Ireland. But for this person, no person is to be treated as not habitually in the United Kingdom who is, and then it's set out, and then it's picked up again in 2.2, which says it's enough to have a, you have to satisfy 2.2, it's enough if you're habitually resident in the United Kingdom, the Islands. If you do not have a right to reside in the UK, the Channel Islands, the Isle of Man, or the Republic of Ireland. And what is said is by having this arrangement for the Republic of Ireland, that is unlawful because it favours the Irish over other EU nationals. And the question is, what is the consequence? And assuming on this hypothesis that I'm wrong, and assuming it was unlawful to make special provision for those who reside in the Republic of Ireland, what is the consequence? Now, where regulations are made in domestic law, which are in part unlawful or in part lawful, the proper approach, if permissible, is to sever the unlawful part. So here, if it is unlawful to give favourable treatment simply on the basis of the residence or the right to reside in the Republic of Ireland, what you do is sever those words. So in 2.1, for example, a person is not to be treated as not in Great Britain if he is not habitually resident in the United Kingdom, the Channel Islands, the Isle of Man, and you strike out the words or the Republic of Ireland. And when you go to 2.2, no person should be treated as habitually resident in the United Kingdom, the Channel Islands, the Isle of Man, strike out or the Republic of Ireland, if he does not have a right to reside in the United Kingdom, Channel Islands, Isle of Man, and strike out or the Republic of Ireland. So the favourable treatment, which on this hypothesis is unlawful, is struck out.
Well, the problem is not so much whether that can be done as a matter of language without destroying the sense of the regulation, but as to the effect.
It's substantive severability.
Indeed.
And the short answer to that, my lord, is for two reasons. The obvious answer is, had it been identified when these regulations were made that making the arrangements for the Republic of Ireland was not permissible, because you couldn't do that without also giving the same treatment to the other 25 member states, what would have happened? And we say, firstly, it is inconceivable, because it would make the whole thing a nonsense, if you had to have right to reside in the 27 member states, because the whole point is to protect the revenue from people coming from other member states. So it's obvious you would not have had a situation where residence in any of the 27 member states was sufficient. And secondly, as you'll see from Fleay, that was the way it developed was initially it was going to be residence in the UK, and then because of the discussions and representations by the Irish government, they extended it to include habitual residence in Ireland. And then when we amended it to include the right to reside, we naturally followed that through and had the right to reside in Ireland. So it was clear that the starting point was the UK. It was extended following discussions with the government from Ireland to residents in the Irish Republic. It would make a nonsense of the policy and the regulations if it simply said anyone can get benefit if they reside in any member state. And what would obviously have happened is if it had been said that the regulations were not right insofar as they included people who reside in Ireland, and that in some way wasn't lawful because we couldn't favour Irish nationals over Latvians, then what you would do is return the regulations to their original scope, which would be that it would be people with a right to reside in the United Kingdom, Channel Islands or the Isle of Man who would be covered, but not people from the Republic of Ireland. And that would be substantially severable. And it's nothing to do with EU law, it's a straightforward domestic law. As I say, my lord, if it was, you have a power to make regulations for England, and you accidentally make regulations for England or Wales, you just strike out or Wales. If you have a power to make regulations for freeholders, and you happen to make regulations for freeholders and leaseholders, you strike out leaseholders. That's what you do. Parliament gives you statutory powers, intending them to be used lawfully. Here on this hypothesis, it is unlawful to give the treatment to Ireland. And what you do, the answer under domestic law, and you never get to EU law, is if it's unlawful to have that treatment, then so long as it's textually and substantially severable, you strike it out.
Well, should we...
All I need to do, my lord, is take you through Hutchinson. I hope I'll finish in about a quarter of an hour to 20 minutes on Hutchinson.
Yes. Well, Mr. Cox, you asked for 2 hours. We indicated at the very start that did seem rather long for a reply. I take it that if Mr. Lewis finishes in about 15 minutes, that will be enough for you.
My lord, yes, absolutely. That will be enough for me. Thank you.
Good. Thank you both very much. 2 o'clock.